Good morning, colleagues. Good morning to everybody. It has gone 9 o'clock. We're going to start. Welcome everybody to the Standing Committee on Social Development in the Western Cape Provincial Parliament. Today is Tuesday, the 15th of September. Before I start the meeting, I just want to remind everybody of the cardinal rules of the Western Cape Provincial Parliament's online conferencing facilities. All participants should please stay mute unless you are going to speak. We allow participants who are members of this committee to use the chat function to raise points of order. And also, if you're not able to access the chat function, please identify yourself to the chair, and we will then make sure that we can listen to your point of order. Any person who is speaking may use both their microphone and their camera. Sorry, I've just had to mute everybody there. So just a reminder, if you are not speaking, please mute your microphone and try to not use the video because it does wane on the connection. But if you are speaking, please turn on your microphone as well as your video. Members, I'm also going to ask that if anybody is making a presentation, whether those are departmental officials or WCPP officials, if you can please make sure that once you have finished your presentation, that the slides are turned off. I'm now going to ask members to introduce themselves, and I'll start with myself. My name is Gillian Bosman, and I chair this committee. I'm going to hand over to the Democratic Alliance. Can we start, Member Mackenzie?
Okay, I was waiting for Member Philander. My name is Ricardo Mackenzie. Good morning, everyone.
Good morning, Chairperson and members. Wendy Philander.
Thank you. Welcome. Anybody else from the Democratic Alliance? We'll move over to the African National Congress, starting with Honorable Windvogel. Is there anybody from the African National Congress in the meeting, the ANC?
Chairperson, good morning, everyone. Member Windvogel.
Morning, Member Windvogel, welcome. Any other members of the ANC with us this morning?
Member Bans will follow since he's still struggling to log in. And for now that I know Member Bans is struggling to get into the meeting.
Okay, anybody from the Freedom Front Plus?
Yes, I'm Peter Marie, I'm here. I just want to clear a matter. You say that only members of this committee. I'm not a member of the committee, but a member of the House. I exercise that right without being able to vote. I can participate. I just want clarity on it.
No, you are very welcome, Mr. Marie. You're welcome at all our committee meetings. Are there any other members of this committee or members of Parliament on the call with us this morning? I would also now like to introduce our procedural officer, Ms. Nomonde Jampe. Nomonde, are there any apologies?
Yes, Chair. We received an apology from Member Makamba Bocha from the EFF.
Okay. I'm now then going to ask for officials from the Department of Provincial and then the officials from the Department of National Social Development to introduce themselves, please.
Good morning, Chair. This is Mzondelehu from the Provincial Department of Social Development. I have my colleague who is going to introduce himself too. Thank you, Chair.
Good morning, Chairperson. The name is Lionel Arnolds from the Provincial Department of Social Development. Thank you.
Good morning, Lionel van der Steeg, Department of the Premier Legal Services.
Are there any other officials from the provincial departments with us? No, I'm now going to hand over. Nobody else? I'm now going to hand over to officials from the National Department of Social Development to introduce themselves.
Good morning, Chair. It's Erica du Plessis. I am at the Appeals Tribunal for Social Assistance Appeals from National. And I am introducing Mr. John Mokwele, who is my colleague, Mr. Trevor John, who's also my colleague, Ms. Molabogeng Urisi, and I think that is from us. I don't see any of our other member or colleagues. If they are, they can introduce themselves. Thank you, Chair.
Thank you very much, Mr. Plessis. Are there any other colleagues from the National Department of Social Development? Okay, now just to give us members an indication of the guests that are joining us, can we ask the other guests to please introduce themselves? And I see the Commissioner for Children for the Western Cape is online, so I'll hand over to Ms. Nomdo to start.
Good morning all. Christina Nomdu, Western Cape Commissioner for Children.
Are there any other guests that are joining us?
Good morning, Chair.
Good morning.
Melanie's Blankenberg, West Coast District Municipality. I'm also introducing my colleagues, Daniel Andrew, Patrick Cornet, Edna Peters, Nizan Makandavira, and Evelyn Shaw Peterson. Thank you.
Welcome to our colleagues from the West Coast District Municipality. Thank you very much, Ms. Blankenberg. Any other guests or colleagues joining us? Okay, it seems that that's the lot, and I suspect we'll have some more people joining us as we go along. Members, the purpose of this meeting is for us to conduct a public hearing on the Social Assistance Amendment Bill. That's Bill B8 B of 2018. That's a Section 76 bill currently in the National Council of Provinces. Just to give some background on the legislative process followed thus far, the bill was referred to the Standing Committee on Social Development by the Speaker on the 1st of June 2020. On Tuesday, the 1st of September, the committee was briefed by the National Department of Social Development on the contents of the bill. In terms of the public participation on the bill was advertised in the mainstream and community newspapers of the Western Cape. Just to note, members, we could not place an advert in the Xhosa newspapers because the time frames for community newspapers, they need 10 days before placing an advert, and we had some struggles with supply chain issues. But what we did do is we sent out a press release in isiXhosa, making sure that it still gets picked up as a news item, and it was fairly well covered across the province. In addition to the paid advertisement, we also sent out a notice for public hearings in all languages to municipalities and NGOs across the province. The committee is thus complying with Rule 118 of the Constitution and Standing Rule 72 of the Provincial Parliament Standing Rules, which indicates that the Provincial Parliament must facilitate public involvement in the process of its committees as required by the Constitution. Members, after the public hearings, the committee will then consider the input made by members of the public, and today's reserved for public hearings for oral feedback, but members of the public have an opportunity to still until the 18th submit written feedback, and we have received some written feedback already. The committee will then take into conjunction with what members' input is and that input of the public. We will then formulate a negotiating mandate on this bill for the province. The meeting of the negotiating mandate by this committee on the bill will be on the 6th of October, and it will then be submitted to the Ncop in the National Parliament on Wednesday, the 7th of October. And those dates are based on the latest program from the Ncop that came through quite late yesterday. The committee will then meet again on the 13th of October for the consideration of the final mandate of the bill. The final mandate will then be submitted to the Ncop in Parliament on the 14th of October, again adjusted for the program of the Ncop. Today we are going to be giving members of the public an opportunity to give input on the bill. We've received some interest, a written submission from Mr. Nyati and Ms. Proudlock, who are both legal researchers from the Children's Institute at the University of Cape Town. If they are here with us today, we'll give them an opportunity to give that input quickly orally, but members would have each received that input as well. I'm now also just going to say up front, members of the public, if you would like to make an oral submission, please let me know by raising your hand, or if you've got access to the chat function, or by just getting our attention so that we can note you down and plan for that. But members, what I'm first going to do is I'm going to hand over to our colleagues from the National Department of Social Development to give a brief overview of the Social Assistance Amendment Bill. I'm not sure if that's going to be led by Ms. du Plessis or one of your other colleagues.
Good day, Chair. I believe I'm leading. Therefore, I'm going to speak on the presentation to the National Council of Provinces. Would you like me to flag my speaking notes, or can I just speak?
Whichever way you're comfortable with. Just bearing in mind that we are broadcasting live on YouTube. So if you have visual aids, that will be very helpful.
Okay, sir.
Just before you go, Ms. du Plessis, Ms. Nomdo, is that an indication that you're going to be making an oral submission?
Yes, Chair, please, if I may.
Perfect. I've noted you, ma'am. I'm handing over to Ms. du Plessis now.
Thank you, Chair. I'm trying to go into this presentation of mine. I was born before technology, so I'm just trying to see what I can do. I don't know if you can see the presentation.
Yes, we can.
Okay, good. Okay, the introduction to this is the following. The Social Assistance Amendment Bill was introduced to the National Assembly on 13 April 2018, but the amendment bill unfortunately lapsed in May 2019 due to the change in administration. It was then revived in October 2019 and subsequently considered by the Portfolio Committee on Social Development. The committee held public hearings and received written comments on the amendment bill. The vast majority of these comments supported the proposed amendment bill, and the committee approved it on the 11th of March this year, with minor amendments. The amendment bill was then sent to the National Assembly, who passed it and referred it to the National Council of Provinces for concurrence. The National Council of Provinces is now seeking mandates from all the provinces to enable the Council to respond to the National Assembly It's a request for concurrence. The provincial legislature is thus conducting public hearings to obtain the views of their constituencies so that they can then take forward their provincial mandates to the Ncop. Now, the objectives of the bill are the following. In addition to providing a few minor amendments to definitions, the amendment bill has three main objectives. The first objective is to empower the Minister of Social Development, with the concurrence of the Minister of Finance, to make additional amounts payable on top of existing social grants. This will enable the department and SASSA to implement the extended child support grant policy, which seeks to pay an additional amount for orphans living with family members that's on top of the existing child support grant. South Africa has a large number of orphans, and most orphans are raised by grandparents or other family members. However, due to high levels of poverty in the country, the foster child grant became the default grant for supporting orphans. However, the majority of families takes care of orphans could not access the foster care system owing to overwhelming numbers and the limited resources within the government to place those children in foster care. The foster child grant and the foster care system were originally designed for children in need of care and protection. These are children who have been abused or neglected and removed from their caregivers. Most orphans do not fit into this category and are safe in extended family environments. This resulted in many vulnerable children not being able to access the foster care system. The aim of this policy is to provide extra income support to orphans living with family members so that they do not have to go through the foster care system. This will relieve the burden on the foster care system and allow the department to utilize their social workers more effectively while providing additional income support to orphans without them needing to go through the cumbersome foster care system. Applicants will not require a court process nor the associated social work process before being able to apply for the additional financial support. However, once the grant is allocated, they will be deferred to the Department for Social Services and Support. The second objective of the amendment bill seeks to streamline the appeals process. The process at present is made up of two parts. If an applicant applies for a social grant and SASSA rejects the application has a right to appeal. However, before they may appeal, they first need to go back to SASSA and request SASSA to reconsider their application. In the Principal Act, this process is called reconsideration decision by agency. SASSA has then 90 days to reconsider the applicant's appeal, and in the vast majority of cases, they still reject the application, as SASSA does not consider the merits of the case then. They just check whether they have complied with all the administrative requirements provided for in the legislation. Only after an application has been reconsidered by SASSA, the applicant may, if he or she is still in disagreement with SASSA's reconsidered decision, approach the tribunal to lodge an appeal. The appeals process itself also takes 90 days. Thus, the full process takes 180 days, which makes 6 months. The internal reconsideration process in SASSA causes significant delays for persons accessing their right to appeal relating to social grants, without adding any substantial value. The amendment bill therefore proposes to remove this whole process and allow an applicant the right to lodge an appeal directly with the independent tribunal if still aggrieved or dissatisfied with the outcome of a grant application or a decision made during a review of grant by SASSA. Therefore, this would reduce the appeal time frame from 180 to 90 days. The third objective is to change the organizational structure of the proposed Inspectorate for Social Assistance from that of a national department to that of a government component. Section 24 of the Social Assistance Act provides for the establishment of an inspectorate. However, this section has not yet been promulgated, as it provides for the inspectorate to be a national department. And given the number of national departments in South Africa, which currently exists, and the significant costs in establishing national departments, another department is not needed. Hence, the amendment bill seeks to change the structure of the inspectorate to that of a government component within the Department of Social Development. The proposed inspectorate, however, must be able to maintain its independence and carry out its functions without interference from the department or from SASSA. Establishing the inspectorate will assist in ensuring that the issues of fraud and corruption are adequately addressed. As provided, the key functions of the inspectorates are to investigate fraud, corruption, and theft. They can investigate forms of financial and service mismanagement, conduct financial and compliance audits, investigate any criminal activity within SASSA and in connection with their functions, duties, and operations, as well as maintain the integrity of the social assistance framework and systems. It also envisaged that it should combat social assistance abuse and develop a complaints mechanism. Therefore, in conclusion, these objectives are aimed at improving the efficiency of the social grant system, enabling improved benefits for orphans and quicker access to the appeals tribunal, and reducing the potential for fraud and corruption within the social grant system. And that is my conclusion there, Chair.
Thank you very much. I'm now going to, I'm not sure why I'm echoing there. Members and colleagues joining us from outside of the committee, are there any questions to the department on that input given? Are there any comments, Mr. Heu, and your team that you'd like to add? Perhaps on the
not see the hands.
Thank you, Chair. My colleague.
Mr. Heu, you can go ahead, and then after that, we'll to Mr. Mackenzie.
Can you hear me, Chair?
Yes, I can.
Good. My colleague has got just a few comments. My colleague Leonard Arnold has got a few comments to make, Chair. Over to you, Leonard.
Good morning. Thank you, Mr. Ehu, and good morning, Chairperson again, and honorable members. Just from the department side, the department welcomes the Social Assistance Amendment Bill, as we believe that the realization of socio-economic rights are critical to overcoming the critical challenges of poverty and inequality. The department also welcomes the bill in the context of the tremendous strain on the current foster care system and the need for much needed social work services to be directed to prevention and early intervention work. And the bill will ensure that the majority of orphans with relatives are able to access adequate social assistance through the top-up grant. Chair, the social security, we believe, is an important safety net that helps relieve poverty and diminishes some of the immediate hardships. And also, given the challenges of poverty and inequality, it's important to have an effective social security system, Chair, that responds adequately to the needs of vulnerable. We believe that social assistance in terms of this amendment bill is an important pillar of the overall social security system and gives adherence to Section 27 of the Constitution, Chair. It is also important that we assess the legislative changes against the prevailing reality of those that this policy seeks to serve and protect. And then just in the context, Chair, in terms of the tribunal that has been proposed, Chair, we also of the belief that retired social workers are an important resource to also consider in terms of the tribunal. But also as a province, we also believe that this Amendment Act will also bring some greater alignment between the Disaster Management Act, which will hopefully contribute to greater coordination and response times in terms of disasters. Also given that our province has witnessed major disasters taking place, and therefore the lived experience of those that find themselves as unfortunate victims of disasters are very important to consider in this context, Chair. So therefore, we believe that this bill will hopefully assist us to ensure that those that require the necessary services are able to access that without undue delay in terms of administrative processes. Thank you, Chair.
Thank you very much, Mr. Arnolds. I'm now going to hand over to Mr. Mackenzie.
Thank you, Chairperson. Chairperson, I've been largely, and I think some of my fears has now been covered by the input of Mr. Arnold. I just wanted to get an understanding about the timelines for the implementation and how will this affect individuals that has already applied via the foster grant system, for example, for child grants, should this legislation be implemented? Will they immediately go into the new system or will they have to reapply? Thank you.
Thank you, Member Mackenzie. I'm going to hand over to Mr. du Plessis, if you could answer that.
Good day, Chair. I would like to request that my colleague, Mr. Trevor John, or Ms. Molebogeng Urisi, who's working directly with foster care, can assist in this answering this question, please.
Thank you, Chair. Good morning, everybody. As Erica has indicated, my name is Molebogeng Uriesi. I am in the Social Assistance Directorate. Regarding the foster care system and children who have already applied and the processes are in court or the administration process has started, the implementation of the increase of the child support grant for orphans and children in child-headed household is not going to interfere with the foster care system. So it's two different processes. The foster care system, as it has been indicated, was initially designed for children who are in need of care and protection. So those children will continue with the process, but the increase of the child support grant for orphans and children in child-headed household will assist to relieve the clouded foster care system. So our community members who are raising orphans and and those children who are in child-headed household will have an option to apply without the overloaded process of going through the courts, because sometimes it can take years, it can take months for children who are in the process of applying for foster care. And sometimes we find a lot of our children even over, aging without even accessing the foster care system. So this will assist those children already who are living with orphans who are within families, and those children who are heading households without a parent. So it is an option that will be there, where the administration will be just through SASSA and not the TDS foster care system. Thank you. I will hand over to Trevor John regarding the process of the bill and and how the bill will be passed. Thank you.
Thank you.
Thank you, Honourable Chair, members and participants. At this point in time, we will have to await the enactment of this piece of legislation, and once the legislation has been enacted, we will proceed with the publication of our regulations. So we do have draft regulations at this stage, which outlines the application process and procedures. It's straightforward. It's very similar to somebody applying for a child support grant. The only difference would be the additional amount payable if that child is an orphan or in a child-headed household, and would then be eligible for the additional payment. Thank you, Chair.
Thank you. Member Mackenzie, I still see your hand. Is it a follow-up?
Yes, Chairperson, just a follow-up for clarity, if I may.
Go ahead.
Thank you for that. I really appreciate it. And I think that's actually where I wanted to go to, Chairperson, just to get an indication of the timelines, because obviously many community and civil service organizations has given input into the bill. We know the parliamentary process and the parliamentary timelines. What I'm trying to get to is when the bill is passed and it's been ascended by the president, where is the department's process, as you just indicate, in drafting the regulations and publishing so that people know what to do? Because part of the problem with many well-intended legislation is it gets published, but then it takes another year or two for it actually to be implemented, and that's where the hold-up generally is. Thank you, Chair.
Thank you. Mr. Trevor John, shall we hand back to you for that response?
Thank you, Honourable Chair. Yes, indeed. The department currently has, I would put it, a rough set of regulations that we have crafted. We just need to have that put into technical and legal format, and then we are able to publish those set of regulations for invitation of public comments, and then obviously incorporate those and then have a final set of regulations published. But again, you've got to bear in mind that we want to do this. We're hoping to do this, as quickly as possible, so that once the bill has been enacted, we have regulations, out as soon as possible. Thank you, Chair.
Thank you. If I could maybe just ask, following on to that, a big part of what the bill seeks to do is to align to the Disaster Management Act when it comes to assistance of social relief of distress. Will those regulations be speaking to the internal arrangements of within SASSA as well, and how that affects it? Because what we know, for instance, in the Western Cape and in the metro of the city of Cape Town, for instance, the process in terms of how disaster relief by SASSA is processed has changed several times. So it used to be that it was contracted to local NGOs through the municipality, and then that process changed, where the contracting of support was done centrally. So I just wanted to ask how that will affect it. And then my next question is around clause 4, where it seeks to insert section 12A that provides for the prescription of additional payments linked to social grants. And it says there that such prescription must take place in concurrence with the Minister of Finance, but it doesn't specify the nature and circumstance under which those payments will become payable. So there's no specification there. So the right afforded to the Minister to differentiate on the basis of need between the beneficiaries of social grants is also not qualified. Do we think that that may lead to discriminatory practices or some form of irrational application because it's not specified? Or is that something that's going to be clarified in the regulations?
Yes, so the regulations basically will specify the conditions under which these additional payments will be made. So, for instance, we're regularizing the 20 Rand top-up that is currently being paid to older persons, 75 years and older. And in this instance, with particular reference to the instance of orphans and child-headed households. And yes, indeed, we will stipulate, the provision for disasters and how these will be dealt with in the regulations. Thank you, Chair.
Thank you. And then just on clause 9, there's the insertion of the right of delegation of the executive director. So, the way I've read that clause 9, it doesn't seem like that right is limited. So the power conferred on the executive director by the Principal Act may be delegated to a staff member or an officer of the inspectorate. And it says that the executive director may authorize a staff member or officer of the inspectorate to perform any duty which she has been authorized to perform. Is that not perhaps also an unrestricted discretion and also open for abuse? I'm not sure who from the department would like to take that one.
It's Mrs. Du Plessis speaking. Through you, Chair, I believe there will be no discriminatory or interference because the inspectorate will consist of officials who's also appointed by the minister. So I believe we can convey your fears here in ensuring that there will be no discrimination. I hope I answered your question.
Okay, my fears are not entirely allayed, but I will also wait for those regulations. Members and colleagues, are there any other questions before we move on?
I hope you now and then look at the hands, Chairman.
I am looking and I just saw your hand going up, Member Murray, and I see Member Mackenzie's hand is still up. I'm going to hand over to Member Murray.
Thank you. I'm very worried. I see that this amendment, social assistance amendment, has now transferred the responsibilities more from the National Department to the Department of Social Development. That's a good move. That's a good move. But did you tick all your boxes? I mean, to what extent is more and more money, when you said we have limited resources, given to in child support and also to foster care? To what extent is this abused? Does this contribute to the high level of pregnancies of unwedded mothers, especially in the rural areas, which I've come across, where mothers have 4 or 5 children because they rely on the children's grant? Did you address all the problems relating to problems which you're trying to address here? We are trying to say that we got to protect children. We got to care for them. We have limited resources. But the only answer we seem to have is every year give them a 20 rand more. Did you look at how many children are without fathers, growing up without fathers in homes? What are the underlying factors here? And I know that all communities do not have this extended family customs. I know with some communities and in some cultures that is a practice. Grandmothers raise the children or aunts. It doesn't happen with everybody. I want to know to what extent you are addressing the real problem of gangsterism, children that grow up on the streets. I see here where I live, mothers standing at robots with children of a few months old on their arms at the robots asking for money. I want to know whether you made sure that there is something in this amendment bill that will cause the Department of Social Services to regularly families who get foster care grants to see the conditions under which these children are living. Are they fed properly? Are they clothed properly? And the conditions under which they live? Or do you just consider yourself a paymaster that every month make sure that this person gets his 300 odd rand a month? Are we addressing the real problems here?
Thank you, Member Murray. Member Mackenzie, I see your hand is still up.
Apologies, Chair, that was earlier on. I just lowered my hand.
Okay. Are there any other questions from anybody else online? Perhaps a member of the public?
My hand is up, Chair.
Okay, Member Bako Force, you can go ahead.
Thank you, Chair. I have 3 questions. First of all, I want to say we as the ANC welcome the objective of the bill and we are in full support of it. As we can see, it will assist vulnerable, especially the orphanage children. It also reduces the application period and cuts the red tape. We just need to understand that cost all the delays in the process. How will the process be fast-tracked from now on? And when can we expect it to be passed? I will ask because there is a greater need for what the bill seeks to achieve. My second question is with regards of the tribunal. What will be the composition of the tribunal and how will it function in provinces? That's the second question. My last question, the establishment of the Inspectorate for Social Assistance is a necessary measure, yes. We just need to know how will its independence be ensured and what will be its powers and functions. Will the people be able to lodge complaints directly to it? That was my last question. Thank you, Chair.
Thank you very much, Member Bako Force. Colleague, I'm going to ask that our colleagues from the department answer those questions.
Thank you, Chair. It's Erica du Plessis speaking again. The establishment, I'm jumping now the gun. I'm going to go to the last question first. The establishment of the inspectorate. In the current social amendment bill, section 24, the inspectorate's powers are set out word for word. And yes, people will be able to approach the inspectorate directly for any fraud investigations or suspected fraud and investigations. I'm going to hand over once again to Ms. Molebogeng Urisi to answer all the other questions and the fast tracking of the bill. I believe Mr. Trevor John has already touched on, but he can do it through you, Chair, after Ms. Molebogeng Urisi. Thank you.
Thank you, Chair, and thanks, Erica. Honorable, I'm going to respond to Honorable Murray's concerns regarding whether, as the department, we are looking into other challenges that are facing our communities. And as the national department, we are continuously looking into the impact of the child support grant and the issues of our vulnerable communities and how we can continuously assist as the department in order to alleviate poverty. And one main objective of the social assistance amendment bill as it stands is that it aims to assist orphans because the needs of orphans are often more than other children. Just to give an example, sometimes we find that families take in orphans within their households, and they have to stretch their limited resources to accommodate an orphan. And in a lot of cases, that can also cause other social ills within families. So specifically assisting families in order to address issues of orphans, the Social Assistance Amendment Bill will be able to provide, in the regulations, we have indicated that it's going to be 50%, an additional 50% over and above the current child support grant. So we looked into how, sustainable and the numbers of orphans that we have in the country, and addressing issues of needs that are more than other, if you compare with other children. Basically, it means that we also assist to address issues around vulnerabilities. Just to give another example, if perhaps a young girl who is an orphan, some of her needs are not addressed, basic needs like cosmetics, they might find themselves wanting to go out and seek support elsewhere. So it's quite important to address and understand issues around vulnerabilities. And also, because of the administration, long administration, and the burden on our foster care system in the country, increasing the child support grant for specifically orphans and children in child-headed households will assist, very much to ensure that issues around vulnerabilities are reduced. And those are some of the psychosocial issues that we address as well. I hope I was able to respond. Thank you.
Can I give a follow-up, Chair?
Yes, you may, Member Murray.
Thank you so much for the response. What I really wanted to know is, I'm so happy that we in the Western Cape are now delivering people's medicine to their homes, old people. I want to know whether we can extend this, if the health can do it, and I proposed this some time ago, can social services make sure whoever gets a foster care grant, that those homes are visited to make sure the money is actually spent for the welfare and benefit of the children? I'm very serious when I ask this, because I come from a community that I've noticed a lot of abuse, and I've listened to children talking who have foster parents. Do you visit these homes? How regular do you visit these homes? How regular do you interview foster children? Or do you just let them the parents have the money, but nobody ever go and check up if the money is spent to benefit the children involved? That's my question.
Thank you. I'm going to hand over back to the department to just answer that follow-up question.
Thank you, Chair. The social workers in our country have been burdened with responsibilities that some of them are unable to meet due to quite a number of reasons. And children who are in need of care, those who are in the foster care system, as we have previously indicated, the foster care system was designed to cater for children who are in need of care and protection. And with the number of applications that we receive as the department, our social workers end up being, focusing on other administration or administrative responsibilities. So the implementation of the Social Assistance Amendment Bill will assist for, to reduce the load that our social workers carry. And in that aspect, the social workers will then be able to put more resources and more focused into children who are in need of care and protection. So the increasing the value of the child support grant for orphans will reduce the workload and the burden of the foster care system. And we are hoping and anticipating that now social workers will be able to focus on the type of work that they specialize in. Thank you.
Thank you very much, and thank you, members, for your questions. Members, I'm now going to hand over to the input from the public and input from stakeholders, and I've thus far received only an indication from the Children's Commissioner for the Western Cape, Ms. Christina Nomdo. So I'm now going to hand over to Ms. Nomdo for her input. And I ask again if there's any other stakeholder online that would like to make an oral input, you're more than welcome to just get my attention and I can put you on my list. But Ms. Nomdo, I'm handing over to you.
Morning again, Chair. May you guide me? Would you like me to put up the input on the screen, put on my video? Which do you prefer?
Yes, please. You can do both.
Good morning, all. Am I, as well as the submission, clearly visible to all?
We can see the submission with your lovely logo. We can't see you yet, but that's fine. You can carry on.
I can see us, Chairperson.
There we can. Okay. My internet is probably slow.
Thank you very much for this opportunity. It is a groundbreaking opportunity for the Office of the Children's Commissioner to engage directly with the parliamentary process, and I thank the procedural officer for making sure that I received the invitation and for welcoming me today. My input is very succinct and it focuses on the Act and also child participation in general. So it says, the Commissioner for Children supports the amendments to the Social Assistance Act relating to the child support grant referred to as the CSG. The amendment enables family members who care for orphan children to receive a higher CSG. This is better than applying for the foster care grants, which takes more time from social workers and courts to ensure smooth administration. This frees social workers up to do more work with families, which is a necessary violence prevention approach. In addition, the Commissioner for Children notes that children have the right to be involved in all decisions affecting their lives. Thus far, children have not been adequately included into the lawmaking processes. For example, the group of children who attended the interviews of the Commissioner for Children were not asked their views. It is important that we evolve lawmaking processes and become a more mature democracy where everyone, including children, finds a way to be heard by decision makers. Very soon, we are likely to see the call for public hearings to make input into amendments to the Children's Act. This is an ideal opportunity to develop a process for children's hearings and involvement in Parliament. The Commissioner for Children will support especially the Western Cape Parliament to develop a child-friendly process for children's hearings so that we can also hear their inputs. I thank you.
Thank you very much, Ms. Nomdo. And I have to say, we're very grateful that we are a province that has a Commissioner for Children that's able to assist and guide the Western Cape in child participation. Because at the moment, the processes of both the national parliament as well as the provincial parliament does not make space for children to actively participate The only space available at the moment is for children to make submissions. And I remember before we start with the interviews on the Commissioner for Children, we received several submissions from children on what they would like the Commissioner's role to be. But we do need to find a way to adjust how we work to ensure that children's participation takes place, especially also making sure that children understand the legislative process, and also that we're able to translate a lot of these verbose documents into understandable snippets. Colleagues, I'm going to ask again if there are any other stakeholder that would like to make a presentation or would like to ask a question or make any input. Ms. Blackenberg from the West Coast District Municipality, would you and your colleagues like to make an input or ask a question? Do we still have colleagues from the West Coast District Municipality online?
Hi, Chair. Sorry, I've missed you.
I was just asking, ma'am, if you would like to ask any questions or if you or any of your colleagues would like to make an input on the Social Assistance Amendment Bill.
Nothing at this stage, Chair, but we will submit our input.
Perfect. Thank you. So just another reminder, members of the public have until the 18th of this month to submit a written submission to the committee for us to consider when we are formulating our negotiating and final mandates. Members, can I ask if you have any questions or if any of our colleagues from the different departments have any other questions?
Chair, it's Ms. Du Plessis speaking.
Yes, you may go.
I believe that I skipped a question about the establishment and of the tribunal and the working in the provinces of the independent tribunal. It must be mentioned that the tribunal was already established in 2008, and we currently already have a working independent tribunal. Furthermore, we have provincial offices in 3 of the provinces, namely Eastern Cape, KZN, and Gauteng. Furthermore, we as National Department has dedicated provincial coordinators for every province, and they go and visit SASSA there and do communication strategies and workshops to bring to the attention of the public, and especially in rural areas, the working of the tribunal and how to lodge an appeal and how the whole process is working. I hope that suffices for the question that was asked.
Thank you very much, Ms. Du Plessis. Colleague, thank you very much for that, ma'am. Colleagues, before I say thank you to the department and the officials for joining us, I just wanted to ask that Mr. Arnold from the Provincial Department, if you could just perhaps submit the oral input that you gave, if you could submit that to our procedural officer as a written input as well, just to make sure that we've got the department's comments recorded in writing as well. If you could make sure that Nomonde gets that, that would be very helpful.
Will do, Chairperson.
Thank you very much. Members, I'm just going to ask as a final round, does anybody else have questions before we excuse the colleagues of the department?
Chair?
Yes, Member Murray, you may go ahead.
I just, as a matter of interest, excuse me if I should have read the whole amendment, because I'm not a member of the committee, I didn't. But I know there are several tribunals, the Housing Tribunal, for instance, their decisions are final and you can't go to court to appeal a decision of the Housing Commission. Does this tribunal have the same authority as a court? If the tribunal take a decision, what is the legal status of that decision? Is it open to appeal or is it final? And can anybody approach a tribunal or must it go via the Department of Social Services?
Okay. Mr. Plessis, do you want to answer on the legal status of the tribunal?
Yes, sir. The tribunal's decision is final, although in terms of PAJA, the appellant, if he is still dissatisfied, may approach the court within a set period of 180 days from the decision that has been taken by the independent tribunal. That the final say is with the tribunal, but in terms of the PAJA, they may still approach court thereafter. Thank you.
Thank you very much. Member Murray, does that satisfy your question?
Yes, the tribunal, must it be a legal practitioner that represents any applicant, or can they represent themselves before the tribunal, or appoint anybody to represent them, even if it's not a legal practitioner?
Chair, through you, I believe, I believe it's a fair question that if any appellant can directly approach the tribunal, they don't have to work necessarily via SASSA after SASSA's decision. They don't have to necessarily work through a legal practitioner. They can lodge their appeal directly with the tribunal. And they may represent themselves. It must also be noted that this is all based on documentary evidence that we obtain through SASSA, which was lodged with SASSA, because the independent tribunal has the powers to override SASSA if we are subjected to exactly the same evidence that was presented to SASSA. Thank you. Thank you, Chair.
Thank you very much for that. Member Mackenzie.
Chairperson, just the last point, and just for the avoidance of doubt, the the executive director, whatever you want to call it, the independent tribunal, obviously gets appointed by the minister, is that right?
That's correct, yes. That was correct, yes. During the presentation to the National Assembly, they requested that we put in a provision that the minister may appoint the independent tribunal after consultation with Parliament, and therefore and it was approved as such, that the minister may appoint after consultation with Parliament.
Chairperson?
Yes, Member Mackenzie?
So just for the avoidance of any doubt and for my complete understanding, you said Parliament recommended that the minister may or appoint the person. So it's not a parliamentary process where they recommend a candidate. It's a process that the minister can initiate, and if the minister, he or she, is happy, then refer the candidate to Parliament for concurrence or otherwise. It's not a process, for example, where Parliament advertise the persons, they then recommend 2 or 3 people to appoint. Am I understanding correct? It's a ministerial process and not a parliamentary process.
Through you, Chair, yes, sir. It is a ministerial process. We advertise in the broader media throughout the whole country, and the minister and if all people who qualify are then presented in a list to the minister with appropriate qualifications, And we believe from now on that list will also go through to Parliament via the Minister. Thank you.
Mr. Mackenzie, are you covered with that response?
Yes, Chairperson. So I just want to make sure that I don't want to misquote people or misunderstand it. It's a ministerial process. I got to thank you very much for that. But then the minister appoints the person and informs Parliament that she has appointed, whether it's Ricardo or Gert or Thabo, doesn't matter who it is. And then Parliament takes note of that. The process does not go to Parliament for ratification. Is that I just want to make sure I fully understand it.
Can I also, just before you go, Mr. du Plessis, just take Mr. Murray's question as well?
I would like to know, is the Premier and his Minister of Social Services at all involved in decision making, as is the case with the Police Commissioner? Police Commissioner, the province has a say because it affects the province. That's why it's going to the Ncop. Is the Premier or his Minister of the Western Cape at all consulted with the appointment of a tribunal in the Western Cape?
Thank you. Mr. du Plessis?
Chair, through you, I'm going to answer the second one first. No, sir, the Premier or the Minister in the Western Cape are not part of the process where the Minister for Social Development appoints the tribunal.
Danger signs, danger signs.
Okay. Secondly, I just want to maybe hand over to my one colleague, Mr. John Mukwele, to assist also with answering of this question. Thank you. John?
Thank you, Honorable Chairperson. My name is John Mukwele, working for the Tribunal. So what I'll try to explain is that the Tribunal is an institution that is separate from the administrative staff in the department. And those are independent people who are appointed from legal practice and also from the medical fraternity. So we're appointing those as independents. So the process that is being envisaged is that the minister will advertise for the appointment, and once the applications have been received, all those applicants that have been shortlisted for appointment will then be run through Parliament, through the portfolio committee, to consider the names and say, are these applicants fit and proper to be appointed on the tribunal? The tribunal does not have an executive director. It's a component within the department. It's not an institution separate like other tribunals, which are separate institutions, but it's a unit that is also independent in its services to ensure that there's no influence either by the minister or SASA in the decision that they have been taken. Also, we need to remind members that the responsibility of the minister in this regard is a national responsibility. So provinces are not involved at all in respect of the decision that have been taken regarding the tribunal. So what is happening is that the minister make a decision and he or she informs the colleagues in the process in the provinces in terms of what are the things that are happening through the report that have been submitted. But in this instance, the minister is a national responsibility by the National Minister of Social Development to run the business and of the tribunal, where they're accountable to her in terms of the responsibility and reports of what has happened, how many applications have been received, and how many have been processed in the process. Thank you.
Thank you very much.
Speaker,
yes,
Chairman,
yes.
Why bother to consult us at all? The question we should ask as a legislature, why does National bother to consult or brief us if we are ignored in any processes that will follow or emanate from this amendment to the bill? I think that the national government is increasingly forcing their will on provinces, dictating to provinces how they should run their affairs. And we should be very careful of this. The principle involved here is something the Freedom Front will support. Yes, we're going to look after our children. We're going to look after foster kids. But the interference from national ministers and the total ignoring of provincial cabinet is something we can't go with. We cannot support it in that regard.
Thank you, Member Murray. I would encourage you to make a written submission of any amendment that you would like to make to the bill in its current form. And if you could get that to the committee by the 18th, the committee will then use that in its deliberations when considering a negotiating mandate to take to the National Council of Provinces when we put the position of the Western Cape forward.
I thank a request, an opportunity, Mr. Chairperson. I will certainly do so.
Thank you, Mr. Murray. Members, with that, I'm going to say, yes, Ms. McKenzie?
Sorry, you see, the Chairperson, can I just clarify something? And that's why I asked the question 3 times. Because the last gentleman who spoke now gave a completely different answer. And it's important that we get clarity, because when we support or not support the bill, these things will be included in our reasons why we support or why we don't support. Now, the previous speaker before the gentleman, I can't remember his name, I do apologize for that, said the minister appoints the person, and the gentleman now said that the parliament recommends. It's 2 completely separate processes. And I have to, for the record, get a clear understanding. The minister advertised. Parliament look at the candidates like any other process, and Parliament recommends then the person. The first person indicate that the minister advertised and informed Parliament. I just want to make sure we fully get clarity, because it's 2 completely different processes. Is the second gentleman correct, or the first spokeswoman correct? Which is the correct process?
Colleagues from the department?
Chair, maybe this is John Mukweli again trying to, what we are saying is that we are not saying there's the law. What is being provided for is that the minister must, in consultation with Parliament, appoint the members of the tribunal. So what is happening is that the minister will then, after having advertised and having shortlisted people that yes or she is going to appoint, consult Parliament and say, these are the people that I'm going to be appointing. And if there's any objection on a particular name, we believe that Parliament will make an objection to that name to say, no, this one you cannot appoint because of whatever reason that will be the exclusion. But what is happening is that the minister has full responsibility in consultation with Parliament to say, I've shortlisted these people and this one, not that Parliament will do the shortlisting on behalf of the minister. Thank you.
I think where the confusion comes in is the insertion of the word Parliament. The way I understand it, as the act is at the moment, it says that the minister may appoint an independent tribunal to consider an appeal contemplated in subsection 1 in accordance with such conditions as the minister may prescribe by notice in the Gazette. That section of the Act doesn't speak to Parliament. So yes. Can we get confirmation that is Parliament involved, or is it completely a ministerial appointment? Because if it is a unit in the department, I don't see how Parliament is involved.
Chair, what happened is that during the deliberations in the NCOP, the NCOP members recommended that the clause that deals with the appointment by the minister, section 18(1), that says the minister must appoint an independent tribunal comprised of appropriate qualified persons. There must be an insertion that says after consultation with Parliament. That's what has been recommended, and that's what the current bill has, an insertion that says the minister must, after consultation with Parliament. Thank you.
So this is a section that's being added.
Yes, Chair, that's the second.
Yes, sir.
Yes.
Chairperson.
Yes, Member
Mr.
Moran.
McKenzie has got a very valid point. After consultation and in consultation are two totally different legal aspects. After consultation, you give a man a phone call and you say, listen, I've appointed so-and-so. That means I've consulted you. I've told you, I've informed you. In consultation means you cannot appoint anybody without the concurrence of that other person. That's in consultation. Now, if the minister appoints after consultation, it will just be a rubber stamp action.
Chairperson.
Yes, Member Mackenzie.
Yes, I think Member Marais put it probably much more, so say, plat is the way I would have put it. But you know, we're not trying to catch the official out. We're just trying to make sure that we understand. That let me speak for myself, understand what is the change the NCOP wanted. Did the NCOP say the minister advertised here shortlist 3 people, and the minister then sends a fax or email to the NCOP and says, I appointed person 1, 2, or 3, or was the intention of the NCOP to say the minister advertised he shortlists 20 people? She sent those 20 people to the NCOP, and the NCOP then says, out of these 20, we don't suggest Pete Pompies because he was found guilty of dealing with children, so we don't think he's suitable to sit on the tribunal. What was the intention of the NCOP? And that does not come through clearly from the official.
Can our colleagues of the department answer that?
Yes, Chair, thank you. It may be difficult for us to expressly say this was the intention of the NCOP, but what the NCOP really provided is that they were supporting the bill, but suggested that the amendment to section 18.1 must include after consultation with Parliament, which means that they've got their own understanding, as Honorable Marais has indicated, in terms of legal connotation of after consultation. So how they arrived at that pronouncement of after consultation, I'm not in a position to say this is what informed their insertion of that statement. But this is what the NCOP recommended, to say, no, we support, but we want the minister to do that after consultation with us. Thank you.
Thank you.
Thank you very much. Member Mackenzie? Yes, sir.
Thank you for that explanation. That makes a bit more sense. And then in the regulations, if the official can just give us guidance, are they going to submit 20 names to the NCOP and 10 will be provided to the tribunal, or are they going to send 30 names to the NCOP and the NCOP will then obviously give their opinion for 10, because that will give me a better understanding? Or is just the last 2 with the 10 that's going to be appointed to the tribunal, will they send those 10 names, or are they going to send 20 names? And out of the 20, the NCOP will then give feedback on the 10 that must be shortlisted. That will clear my understanding.
Maybe if I could just as a question of clarity insert there, does the regulations in its current form make provision for how the minister must consult with Parliament, or does it leave it open to Parliament to determine what that consultation needs to include?
It's Mrs. Du Plessis speaking. Currently, the current regulations does not prescribe any specific method or provisions regarding how many or how the minister will, how the list will be presented. It certainly, the department will look into it. We already raised this question with the state law advisors, and their response was that it is envisaged that the department, assisted by any selection panel that may be set up, will undertake all the processes preceding the appointment by the minister, such as advertising, shortlisting, and recommended certain suitable candidates to the minister. But before the minister makes then the final appointment, it is envisaged that the minister would, in accordance with the amendment, consult Parliament with regard to the list of persons he or she intends to appoint, providing a summary of their qualifications to enable Parliament to make a sound recommendation. Where other pieces of legislation require members of the National Executive to consult with Parliament, this is usually done under cover of a letter addressed by the relevant minister to the Speaker of the National Assembly and the Chairperson of the NCOP, respectively. Thank you.
Thank you, but it still leaves it open for Parliament to determine whatever processes it wants to follow in terms of what that consultation process should look like. Just to check, Member Mackenzie and Member Murray, are you covered in those responses?
Yes, Chairman, I'm covered, but now that she just added another 3 or 4 words in the last sentence from the State Law Advisor, which she said after recommendation by Parliament. So it seems like there is a role to play for Parliament, but I presume it will be further clarified in the regulations. Thank you. So I don't think we're going to exhaust it now here in the committee.
The amendment at the moment, Member Mackenzie, in section 18(1) is very clear. It says the minister must, after consultation with Parliament, appoint an independent tribunal. So it still sort of puts it in Parliament's court to decide what that consultation process needs to look like.
Yeah.
That's perhaps something we need to monitor in terms of how effective does Parliament want to be in this process.
Okay, no, that's fine. Thank you.
Chairperson, my final comment on this is, because we have different cultures in different of the 9 provinces, and we're aware of it, we're all aware of it, in terms of families, in terms of foster parents, in terms of extended families, the rules does not apply to all community in exactly the same way. Therefore, it's important that each provincial government and their departments should be part of this process, or when they must consider whether any family unit or any applicant should be considered on merit. You cannot have a national minister deciding what should happen in any particular case in any province by his appointees. That province should be in a position to say our demographics are totally different to the demographics in other provinces, and so how we apply this and what weight we attach to what factors, social factors, should be ours and not that of somebody else who have a totally different norms and standards and family compositions. And you get provinces where one husband, he has 5 or 6 wives. In another province, they only have 1 wife. It's totally different. The children are totally differently affected. And I would like the DA and even the ANC to consider this. We cannot let national ministers dictate to provinces any longer.
Thank you, Member Murray. I recognize Member Windvogel.
Hear me?
We can hear you now, Member Windvogel.
Yeah, Chair, but you were clear that we still have time to do submissions. So I don't think we really need to go into that further at the moment, because you mentioned earlier that up until we have time, up until I think you were saying that we have time to do submissions. So because now we are going to engage on another issue or issues. If we go in and you allow Member Murray to go into that space. So my proposal will be that we stay with your proposal, that if we want to do or want something to be included in this amendment bill, that we do our submissions. Thank you, Chairperson.
Thank you very much, Member Windvogel. Colleague Member Van Voorgel is right. Members of the public and stakeholders have until the 18th of this month to make written submissions to our committee, and we still then have some time to consider input from members of the provincial parliament as well. So we do have time to further discuss how we want to move forward. Members, I'm going to say thank you very much to Ms. du Plessis and her team, as well as to Mr. Heo and Mr. Arnolds and our colleagues from the Department of the Premier for joining us. And a very big thank you to the Commissioner for Children and our colleagues from the West Coast District Municipality for joining us. We're very grateful that you've chosen to participate in the work of this committee. You are now all welcome to leave, and we'll ask the officials from the WCPP as well as members of this committee and our colleagues from Parliament just to stay on. But thank you very much for your participation.
Thank you all honourable members as well as Chair. Thank you. Bye-bye.
Thank you, Chair. Goodbye.
Thank you very much. Thank you.
Thank you, Chair.
Thank you, Chair.
Members, in terms of the way forward on this bill after this public hearing, the next stage of the NCOP legislative process is the negotiation mandate on the bill, which has been scheduled for the 7th of October by the NCOP. So the Standing Committee on Social Development needs to schedule our meeting to formulate our mandate by the 6th of October. So can I ask members of this committee if we can meet on the 6th of October from 9 to 12 for the negotiation mandate on this bill? Members, are you happy for us to schedule a meeting on the 6th of October from 9 till 12 for that discussion to take place?
Yes, Chair. 6th of October is, yes.
Thank you. Thank you, Member Van Voorgel.
Chair, Provincial, sorry, I'm just trying to open my diary quickly.
Now, Monday, does it have to be the 6th or can it be before the 6th?
As long as it is before the NCOP negotiating mandate meeting, our mandate as a province need to be ready before the NCOP sits, and so that our mandate can also be considered in that NCOP meeting.
Okay, so our current, if my understanding is correct, we initially had this scheduled for the 23rd, was it?
Yes.
Do we still want to keep it the 23rd?
It was supposed to be, the 23rd is on Monday. That 23rd, we were forcing it because their 6-week cycle was tight in terms of deadline. So we were going to meet on a Monday, and their NCOP mandate was going to be on Tuesday. And now, since last night, they informed us that now they will consider the mandate on their 4th term, which is in October. The committee does not have to meet on a Monday. We can meet on the 6th, or we can meet any date. If Monday is still okay for the members, we can meet on Monday.
So members, can I perhaps propose that Nomonde and I look at the parliamentary program and identify in consultation with members what date would be suitable for us to have that negotiating mandate meeting?
Chairperson.
Please, not a Monday, Chair. It becomes a problem.
Okay, Member Mackenzie and then Member Philander.
I could have misheard, but the 23rd is not a Monday. We're talking about the 28th.
The 23rd is a Wednesday.
Yes, yes. No, because the current meeting is scheduled for Monday, the 28th of September. And the reason I was happy with that date is because I think all of the members are leaving that morning for the education committee from town, and we all will have to be on that bus anyway. So it makes logistical sense that we can just arrive an hour earlier at 7 Wells Street to have our meeting and then depart all together on the education visit, if my understanding is correct. I think you were the only one that was going to dial in because you were in your constituency. And that date may, as opposed to looking for a new date, it makes logistical sense. If anything fails, if I may just quickly continue, we are, and I suspect all of us, and you can help me if I'm wrong, are going to be on that visit for that whole week. And it should be easily to fit in an hour, pre-dinner or whatever, as opposed to looking for a brand new date. That's just my input on this matter.
Right, Member Philander.
Chairperson, thank you. Myself also would be in concurrence with the 28th Chairperson, but I also concur with you and the PO deliberating and informing or consulting with the committee on confirmation of the date. Thank you, Chair.
Chair, can I have can I say something? I think I made an error on to say that the meeting was scheduled for the 23rd. No. Our meeting, the mandate, negotiating mandate, was scheduled for the 21st of September, which is it was going to be on Monday because the Ncop was going to sit on Tuesday, which is the 22nd. But now, since the Ncop has said that they have moved their mandate to the fourth quarter, we don't have to meet on a Monday. And on Monday, the 28th, we were going to meet for a final mandate, which is a final mandate, takes hardly 15 minutes. And I don't think that it will be, I will advise the committee to sit for the negotiating mandate on the 28th, because the negotiating mandate, it tends to take a little bit longer. We have to invite the people from the department, we have to invite legal to come and assist us in drafting. It's not as quick as the final mandate. Hence, the final mandate was scheduled for the for that Monday when the members are leaving, because it's a 15 minutes is to say yes, you support, no, you don't support. There are no, you don't write, you don't motivate as to why. It's yes or no. So it takes hardly 15 minutes or even 10 minutes. But I don't advise that the negotiating mandate meeting now must be scheduled for that morning of the 28th.
Can I propose, Member Philander?
No, please proceed, Chairperson. I just wanted clarity, if I am, Ms. Jamke, correctly, that we remain the 21st for the negotiating mandate and the 28th for the final mandate. If that's the case, it's in order with me, Chairperson.
No, I think what Ms. Jamsha is saying is that we need a little bit more time for the negotiating mandate. And what I was going to do is say, let's go back to the original proposal where we look at the diary. Now that the NCOP has changed their dates, Namonde and I look at the diary, we consult with members, and then we go to the programming authority and we ask them for a date that's suitable once we all agree. We can also look at, it doesn't have to be on the 23rd, it can be in the first week of September, because we've got up until the 5th and the 6th to do it, because we only have to have it to the NCOP by the 7th. So with the permission of the committee, if you give myself and Namonde an opportunity to go look at the parliamentary program, and then take into consideration that Mondays don't always work for everybody. And we then put together 2 dates for the negotiation mandate, as well as a date for the final mandate.
Chair.
Yes, Mr. McKenzie?
Sorry, I just looked at the program again, and we do have dates that we agreed to at the last meeting. So I don't know where the 23rd comes from. I'm not sure if it's just a mistake on it, but the 21st and the 28th is already in the program.
Yes, but those dates are now being adjusted because the NCOP has adjusted their program. They've pushed the ball towards the 4th quarter. So we have a little bit more time. But there's no need to adjust it if our dates are already firm.
But you see my hand.
I don't see your hand, Member Bakubaka first, but I can hear you. Go ahead.
Monday won't work for us, Chair. We are having constituency offices that we have to serve. Monday is out for us because it's a constituency day.
Again, members, can I ask you, do you mind if we go and have a look at the parliamentary program and see which dates are available? Because initially we had from this meeting scheduled from 9 till 12 on Monday the 21st, but members are also going to be on a bus during that time. So it doesn't make sense to have that meeting on that day. We then have some time between that week where we can see whether we can have the meeting there, or we've got some time during the first few days of October to see whether we can have the meeting there. But what I'm asking is that you give myself and Namon opportunity at parliamentary program, and then to come up with a proposal for both days, for both the negotiating mandate and the final mandate. We then come back to members, we see whether it's convenient for members, and then we go to the program authority and we ask them for a date. But at the moment, we know that on Monday the 5th and Tuesday the 6th, there's budget training the whole day. So we will look at other. Members, are you happy with that?
Yes, Chairperson, you guys can go and come and bring back new dates.
Yes, that's fine, Chair. Thank you.
Members, with that, thank you very much for your time this morning. And thank you very much to our procedural officer and our parliamentary support staff, as well as the IT staff, for helping us to facilitate this meeting. I wish you well. The meeting is then adjourned.
Thank you, Chair.